into existence, then the human rights declaration was made. But that was merely a declaration. No implementation was possible. Only declaration is you can declare anything, but a person can get benefit or not. This was the point. So then again there was the exercise and covenants came into existence. Two covenants were there: civil and political rights, UN Covenant on Civil and Political Rights, UN Covenant on Economic, Social and Cultural Rights. Because economic, social, cultural rights, so many states in countries were so poor that they can't do. They can't pay the compensation for the wrongful confinement, for other things. So they said these were the two options. Two covenants were there. And fortunately, when these covenants came in 1976, before that, our constitution had incorporated both the covenants into two parts. One is part third, that is the fundamental rights, that is synonymous to the civil and political rights. Another is the state directive policy, that is part 4, and that is synonymous to the economic, social and cultural rights. So that was there. After that thing was not stopping there, and civil and political rights, that was against the police, atrocities, fundamental rights, all these things you can say. So the question was how to compensate. Then compensation question came. Then optional protocol for civil and political rights came into existence where compensation can be given. India is not a party of the optional protocol, though it is a party of the civil and political rights covenant, but not the optional protocol. So this compensation issue is always decided by the Supreme Court. Sometimes courts give ad hoc compensation like this, but there is no policy and there is no law. How much it can be determined, there is no measurements. So the Supreme Court or courts have the role for that purpose and to determine. In this one, my friend has already expressed this view after the emergency, that is as Jaipur's case, famous case, and so many cases came where the Supreme Court has played a vital role for the protection of the human rights. Even a terrorist was given an opportunity of hearing in the midnight by opening the Supreme Court, which is a historical one. But the question is this. You can say this things, very good things Supreme Court did, but I am asking myself, if one snake is there, how many people will be killed by one snake? You can say one or maximum two. And what you will do with the snake? Naturally you will kill him. But one terrorist is killing 20 people, 30 people, then what you will say? Human being. And for that one, you are opening the Supreme Court when other peoples are waiting from last 30 years for the justice. I belong to the Allahabad High Court, he also belongs to that place. The largest High Court of the world with the largest pendency. More than 1 million pendencies are there. So Supreme Court should have also the role to reduce the pendency, and nowadays the judiciary or Supreme Court has the total control over the high courts and lower courts, and pendency is the responsibility, reducing the pendency is the responsibility of the Supreme Court, for which perhaps nobody has given the time. As I said, Supreme Court opened in the midnight, perhaps to my mind it was published. Nowadays every judge is publishing the judgments to the press. And one thing what happened, one judgment was printed and was given to the press correspondent to publish it. But next day another judge was on leave. So judgment was not pronounced and judgment was published. Reason is this, they are publicity oriented like a politician, so sometimes. So one should think, and Supreme Court should think whether we can do the publicity or provide only the justice by not by name. This is the judgment of the High Court, this is the judgment of the Supreme Court, not the individual. This is the opinion. And I agree that some judges are working in an arbitrary manner, something, and they are not giving these things. But reason perhaps is this, and they are very fast. For example, for me, people are saying very fast, not providing the full opportunity of hearing. So I usually ask to give the written submissions, because pendency is the main question. People are waiting from last 50 years, 30 years, and in civil cases I decided one case from 1916 at that time. So just 4 or 5 years less than a century. So court should think, and Supreme Court should think to develop the jurisprudence for providing the justice, and justice will not be provided and pendency will not be reduced. I think that fundamental right of individual is also deprived. That is not there. So for that one we can fix. Another aspect came during discussions, the appointments of the judges. One study is there, 84% recommendations are from the particular from the chambers of the judges, where they were practicing either from their chambers or from their family members or their relatives. It means that individual person, ordinary person cannot get a chance. There is no competition. I know so many judges, those who could not qualify the PCSJ, but they were my colleagues and they are my colleagues. So no merit, nothing, just merely recommendation. And sometimes recommendations are so bogus. One recommendation recently in Allahabad High Court, the CBI report is this, that he was drinking and was in the Nala. Then, this was the report, and that his name was recommended, perhaps under the pressure. Reason is very simple. The Chief Justice of a particular High Court is always looking for the Supreme Court. He wants to be in the Supreme Court by all means, by hook or crook. This is the one aspect, to be very clearly I am saying, not in a polished language, but in a real language. He wants to be in the Supreme Court. So he was under the pressure. I can ask, when in the government, PM to the Cabinet Secretary has the age of 60 years, and in the judiciary, the municipal magistrate to the Supreme Court, they are discharging the same nature of work. Why their age should not be uniform? Why there is a distinction, 60, 62, 65? If they will bring all the age at par, for example 65 years, then there will be no race for the Supreme Court. And Chief Justice will confine to his High Court and devote, all the judges will devote their time for the judicial work. And nowadays they are busy just for elevations, for these things like this. There's so much politics is there, and perhaps he knows how much politics is there in the for the elevations. When name is there, now 7 vacancies are there. So many people are running from pillar to post. So these are aspects which we can say this is the Supreme Court things. Though Supreme Court did wonderful things, as I said, and this emergency cases and in builders cases for the individuals, they put the fine. And now people are getting the flats which were booked long back, and Supreme Court is also providing the shelters to the shelterless peoples when these are removed. Then compensation is given for the persons who were killed, raped like this. But these are some negative points what I discussed. So time will tell how this jurisprudence will develop by the Supreme Court. And with these words I say thank you.
Thank you very much, Your Lordship, for of course, India is not a signatory to the optional protocol, but all credit should go to the courts for public spirited people to develop this jurisprudence. Well, now I open the floor to our audience for questions to our speakers. We have the mic with Anurag, so if there's anybody with questions that we have.
Which regulate the pendency of the cases before the High Court or the Supreme Court to reduce the pendency, and it can seek the redressal to the Supreme Court immediately. There should be any time limitation to the pendency, that if the case is 2 years, then should be immediately be heard by the judges. If these limitations were there, then the pendency will be reduced gradually. So is there any act or any regulation the Supreme Court in the Constitution which regulate these pendencies?
Exactly, there is no how much time it will take, it depends on the court.
But there should be regulation because...
Maybe, but that can't be implemented. That can't be implemented.
See, there is no point in having a rule which... Because if you don't have enough judges, and if the number of cases coming up before that court is such that you cannot dispose them off in 2 years, then practically it can't be implemented. What we need is a multi-pronged approach to deal with this problem. One is that, of course, today there was a seminar in this Law Institute on use of technology in courts. As to how they can streamline the hearing, disposal of cases, reduce wastage of time in many things, etc. But even if you do all that, you will still not be able to dispose of the cases in 2 years unless you increase the number of courts and the number of judges, and also improve the quality of judges in the courts. So you need to do these two things, that is, appoint more judges, have more courts, and secondly, select the judges or train the judges in a manner such that their quality improves. If you see the disposal or compare the disposal from one judge to another, sometimes there is a difference of 100:1. There are some judges who are not even able to dispose of one case per month. There are other judges who are disposing of hundreds of cases or several hundred cases every month and disposing them off well, dealing with them well. That's because of the difference in the quality. So those things we have to deal with. Without that, there is no point in making a rule saying that dispose of everything in 2 years.
So you can just ask her your
So
question.
my question is, I just would like to ask a question from Justice Chandra, that there may be some cases where some judgment or some order passed by courts would not satisfy a common person's conscience, and people would be dissatisfied with those orders. So in that case, if something wrong has happened, or nobody is infallible, it may be by mistake or by anything, what should be the mechanism if people are not allowed to criticize the orders passed by constitutional courts? As you took this example that the Supreme Court was opened in the night as if something strange has happened, but it was a question of somebody's life and death. And if Supreme Court says somebody was a terrorist, there are instances where it was found later on that no, that there was doubt. There are instances where people are criticizing some judgments, holding somebody as a terrorist. So in these circumstances where people are not given actually a fair opportunity to criticize the orders and judgments of the court in the name of contempt and all, what should you think should be the proper mechanism? Because unless there is proper criticism, there won't be a chances of improvement also.
You have mixed so many points in one question. First is this: a person is bound to commit some mistakes if he will do something. If he will not do any judgment or will not pass any order, no mistake will be done. When he will pass so many orders, there is some mistake may be there. And if mistake is there, the procedure is already available. Move an applications before the same court, which can be corrected, and appeal can be filed. That is one thing. Regarding that opening and this one, I just told when the person was convicted, finally everything was there. So that might have been done in the morning or deferred like this. That was just one example, not the precedence. Had there been a Supreme Court or Super Supreme Court, so many judgments of the Supreme Court might have been overruled by now. By Supreme Court only finality is there. That's all nothing else. So about that mistakes and all these things that can be rectified by the procedure of law. The process of law is there.
Jurisdiction was created for this purpose, so unfortunately it's not being taken very seriously by the Supreme Court. Most of these curative petitions, the manner in which they are dealt with, I don't think that most of the judges even read them. So it has just become a formality. People go through that formality and reject them. Of course, criticism of judges or judgments is allowed, so long as you are not imputing a motive to them. Even motive can be imputed. If you have evidence to say that this judge has given this judgment because he was paid some bribe, etc., you can say that because truth has been made a defense in the contempt law today. But yes, the threat of contempt remains a serious deterrent. Even after making truth to be a defense, it still remains a serious deterrent for people criticizing judgments or judges, etc. This is a problem to some extent.
So I respect judiciary by my heart, but as we all know, judiciary is a protector of constitution. Like any law made by legislation which harm the basic structure of constitution, judiciary has a right to declare it null and void. Similarly, we have seen NGSs formed by legislation by our parliament for the appointment of judges. So why the Supreme Court has cancelled it? That is a good step taken by legislation for